Ready? Exercise number 3, Series B, Legal Matter. Start. This appeal assails the judgment and order delivered by the Division Bench of the High Court of Judicature at Bombay in Criminal Appeal number 46 of 2005, thereby dismissing the appeal of the appellant and maintaining the conviction and sentence of the appellant as passed by the Additional Sessions Judge Islampur in Sessions Case number 39 of 2003 for offence punishable under Section 302 of the Indian Penal Code under bracket for short IPC bracket out. Stop. Next para. The prosecution case in brief, as could be gathered from the material placed on record, is as under: deceased Jayashree was married to the accused prior to about 8 or 9 years from the date of the incident. They were blessed with 2 issues. PW3 Anandi Bai is the mother of deceased. PW5 Ramchandra Chintappa is the brother of the appellant who was residing separately in different part of the same house. It is the case of the prosecution that the appellant was addicted to liquor and used to abuse and beat the deceased, forcing her to get money from her mother. Stop. Next para. On the fateful night of 23rd March 2003, the accused and deceased went to sleep in their house. At the dawn of 24th March 2003, PW5 gave a call to the appellant so that they could go to their field for harvesting jowar crop. The accused opened the door and expressed his inability to accompany him to the field, stating that Jayashree had committed suicide by hanging. PW4 Ramchandra Shankar resides near the house of the appellant as well as PW5. PW5 informed PW4 about the incident. Stop. Next para. The case was committed to the learned sessions judge. Charge was framed for the offence punishable under Section 302 IPC. The appellant pleaded not guilty and claimed to be tried at the conclusion of the trial. The learned trial judge convicted the accused for the offence punishable under Section 302 IPC and sentenced him to imprisonment for life. Being aggrieved thereby, the appellant preferred an appeal before the High Court, which came to be dismissed. Hence, the present appeal, insofar as the finding of the learned trial court and the High Court with regard to the burden of the accused in view of Section 106 of the Evidence Act is concerned. The learned counsel submitted that unless the initial burden is discharged by the prosecution, the burden would not shift on the appellant. Stop. Next para. Homicidal hanging, though rare, has been recorded. Usually, more than one person is involved in the act. Unless the victim is a child or very weak and feeble, or is rendered unconscious by some intoxicating or narcotic drug. In a case where resistance has been offered, marks of violence on the body and marks of a struggle or footprints of several persons at or near the place of the occurrence are likely to be found. None of the well-known signs referred to by the learned author are present in this case. In any case, the medical expert himself has not ruled out the possibility of suicidal death. On the contrary, the post-mortem report shows that the cause of death was asphyxia due to hanging. Stop. Next para. In the light of this evidence, we find that the trial court as well as the High Court have erred in holding that the prosecution has proved that the death of the deceased was homicidal. Stop. Thank you very much.